John David Ruff versus Vanderbilt University Medical Center.
Mr. Ruff, you're welcome to come to the podium.
Thank you, Your Honor. I appreciate that.
I understand you are representing yourself today.
Yes, Your Honor, that's correct.
Then you've been in the courtroom for the last hour, and therefore I'm pleased that you had the opportunity to see how we conduct these oral arguments. And while we welcome to hear what you have to say, we may or may not ask questions of you. So I hope you'll understand that it just means we're trying to get a better understanding of what the positions are. But
Yes, thank you so
anyway,
much.
you have a total of 15 minutes to argue. Do you wish to reserve some of that time to respond to?
Well, thank you for asking me for that. I really do want to reserve 5 minutes, but at the same time, I'd like if the court can indulge me, because the brief is 25 pages long. I have five issues.
We've read that, and you don't have to repeat everything in the brief. So
Yes,
what
sir.
you should use this opportunity is to add depth or color to what you've already shared with us in the brief. But
Yes.
your opposing counsel will only have 15 minutes, and therefore you'll only have 15 minutes. And so we'll set the clock for 10 minutes and reserve 5 for your rebuttal.
Well, I'll tell you what, Your Honor. I won't use the 5 for rebuttal. I'll just use the 15 minutes to go through.
Very good. All right. We'll set the clock for 15 and
Thank you, Your Honor.
waive rebuttal.
I appreciate that.
The floor is yours.
Thank you, Your Honors. I have 5 issues to present to the court, and I'm going to go kind of fast and try to just hit the highlights because I'm limited here. The first issue is plaintiff appellant would submit that the trial court erred by not finding that the complaint was legally sufficient to survive VUMC's motion to dismiss under 10 Rules of Civil Procedure 12.066. I want to first state that if I'm going to be technical about this, I'm going to be technical. And what I mean by that is the motion to dismiss is grammatically incorrect. It's 12.066 that the defendant used in their motion to dismiss, when it should be 12.02 under Myers. So I will move on here. The correct procedure under VUMC's motion to dismiss is to examine the legal sufficiency of the complaint and accept all factual allegations in the complaint as true and in favor of the plaintiff. Accordingly, the trial court clearly erred under Myers by not carefully scrutinizing the legal sufficiency of a complaint and by not accepting all factual allegations in the complaint as true and in favor of a plaintiff appellant. For example, the complaint shows, among other things, that ophthalmologist Brian Fowler's medical eye examination of plaintiff appellant is the same medical eye examination of plaintiff appellant given by the defendant Vanderbilt's ophthalmologist. That could be shown in the record at page 5, paragraphs 15 to 16, and page 2, paragraphs 1 to 5. This is further proof that the complaint is legally sufficient, not frivolous. Additionally, Dr. Fowler's signed and dated medical certification in the complaint is similar to Dr. EZ's affidavit in Hinkle versus Kindred Hospital. In Hinkle, the trial court held, and this national appellate court affirmed, that Dr. EZ's affidavit complies with the underlying concept of the good faith certificate found in 292622. Accordingly, plaintiff appellant respectfully moves this honorable court to find that, like Dr. EZ's affidavit, Dr. Fowler's certification complies with the underlying concept of the good faith certificate found in 292622. I'm going to touch on really quick under the same issue, extraordinary cause now. Plaintiff made diligent extraordinary efforts to comply with Tennessee Code Annotated 292622 Certificate of Good Faith, but was unsuccessful. For instance, plaintiff consulted with 5 total ophthalmologists for the purpose of complying with the good faith certificate. Furthermore, during the initial court proceedings, plaintiff filed a document in open court entitled Plaintiff's Additional Expert Witness Context, which contained 8 additional expert witnesses that I sought for the purpose of complying with the certificate of good faith. Moreover, plaintiff's sister conducted further research on plaintiff's behalf for oculoplastic specialists. Plaintiff appellant further moves this appellate court to approve his reply brief under Myers, which contains a completed certificate of good faith on the form approved by the Tennessee Administrative Office of the Courts. Plaintiff therefore respectfully moves this court to determine whether the trial court erred by not finding that the complaint is legally sufficient to survive VUMC's motion to dismiss under 10 Rule Civil Procedure 12.066. Issue number 2. Plaintiff appellant would further submit that the trial court erred by denying plaintiff's appellant's statutory exemption claim under 2926.121(d)(1), which excused compliance for an expert witness. Plaintiff complied with the statutory requirement of Tennessee Code Annotated 2926.121(d)(1) by giving VUMC a HIPAA-compliant medical authorization with the pre-cert notice on July 12, 2021. VUMC, however, did not timely produce these medical records to plaintiff appellant within the 30-day deadline of this July 12, 2021 receipt date required by Tennessee Code Annotated 2926.121(d)(1). That's in record page 4, paragraph 11. 6 months later, VUMC provided me with partial medical records. The remaining medical records that VUMC has withheld from this plaintiff without explanation can be viewed in the following parts of the appellate record. Record, page 18, record, page 98, paragraph 7, and record, page 99, paragraphs 11 and 12. Thus, VUMC has violated Tennessee Code Annotated 2926.121(d)(1) because the failure was due to the failure of the provider, defendant VUMC, to timely provide copies of the claimant's records requested as provided in 2926.121 or demonstrated extraordinary cause. Also, VUMC has waived this issue. VUMC's motion to dismiss the memorandum of law did not specifically mention and or challenge patient's statutory exemption claim. Thus, they have waived any response or objection in this issue. Plaintiff relied on the statutory exemption of Tennessee Code Annotated 2926.121(d)(1) and the supporting cases of Truth, Myers, and Priest.
Mr. Ruff, in the trial court, did you bring it to the attention of the trial judge that you were complaining that Vanderbilt delayed or refused to provide your medical records to you in a timely fashion?
Yes.
Okay. And
Yes,
did
sir.
you take the position that that hampered your ability to get an expert witness?
Yes.
Okay.
Thank you for your question. You know, in Truth versus Esquiglove, the district court held that the doctor's failure to provide patient with full medical records excused plaintiff from filing a certificate of good faith. In Priest, the U.S. District Court in Nashville stated a plaintiff can avoid dismissal with a showing that the omission was due to the failure of the medical provider to timely provide records or showed him extraordinary cause. In Grizzle, the Tennessee Court of Appeals for the Eastern Section stated that appellant has the right to the complete copies of his medical records under Tennessee Code Annotated 2926.121(d)(1). Furthermore, the appellant complies with this requirement by providing a HIPAA-compliant medical authorization with the pre-cert notice which I provided. Plaintiff complied with that consequently, the trial court erred by denying plaintiff's statutory exemption claim under Tennessee Code Annotated 2926.121(d)(1). See, I'm going kind of fast because I want to get all these issues in. Issue number 3 is Plaintiff appellate would further submit that the trial court erred by not converting VUMC's motion to dismiss into a motion for summary judgment. Standard review is de novo. And standard de novo is for all my 5 issues. That's the standard of review is de novo. VUMC's motion to dismiss incorporated, relied on the memorandum. The memorandum relied on all unreported cases are attached as Exhibit 1. That constitutes extrinsic evidence outside the pleadings. In addition, I filed in open court on the initial court proceedings on June 3rd, 2021, additional expert witness contacts, which further constitutes extrinsic evidence outside the pleadings. In addition to that, I filed a motion to alter to amend, which contained an affidavit, which further constitutes extrinsic evidence outside the pleadings. Neither VUMC nor the trial court specifically mentioned this affidavit or this conversion issue. Thus, again, VUMC has waived any response or objection in this matter. Now, in Fincham versus Ace, the court, in citing legal precedent, stated the trial court, upon a motion to dismiss Friday to say the claim retains the discretion to consider extrinsic evidence outside the pleadings, but if it does, the motion shall be treated as one for summary judgment. And Martin versus Rolling Hills, the Tennessee Supreme Court, in following legal precedent, stated the following: because the defendant submitted matters outside the pleadings in support of the 12.026 motions, the motion shall be treated as a motion for summary judgment. The trial court considered the extrinsic evidence outside the pleadings. Therefore, the trial court committed reversible error by not converting VUMC's motion to dismiss into a motion for summary judgment. Issue number 4, plaintiff appellate would submit that the trial court erred by denying plaintiff's common knowledge exception. The standard reviews de novo. Jackson versus Burrell, the Tennessee Supreme Court made the following statement under the common knowledge exception. The resolution of this case depends on whether the common knowledge exception applies in healthcare liability cases. This exception comes into play when the subject matter of the alleged misconduct is within the understanding of laypersons of the public. Courts determine on a case-by-case basis whether expert testimony is necessary in a healthcare liability case. Plaintiff's common knowledge exception issue in paragraph 19 of the complaint is the end result of VUMC doctors failing to permanently and properly position plaintiff's left eye back in the left eye socket. The final medical mistake by VUMC doctors is within the understanding of lay members of the public and thus contrary to VUMC's position that the proper steps and techniques for complex ocular surgery are not within the realm of common knowledge. Plaintiff therefore respectfully moves this court to determine whether the trial court erred by denying plaintiff's common knowledge exception claim under Jackson versus Burrell. Lastly, issue number 5. Plaintiff appellate would submit to this court that the trial court erred by not finding that Tennessee Code annotated 2926-121, finding the certificate of good faith constitutes an unconstitutional application of the law between self-represented parties and licensed attorneys. I had a
Mr. Ruff, I have questions about
yes,
that
sir.
issue. So I'm looking at your brief.
Yes, sir.
And in your brief, you say, you're not, and you underline the word not, challenging the constitutionality of the statute.
Yes, sir.
But then you say in the next line, it's the application of the statute, you say, denies pro se litigants the equal protection of the laws. So if it's not the constitutionality of the statute, what are you saying actually is denying you the due process of law?
Thank you for your question. This is not a facial, I'm not attacking the statute.
Okay, I see what you're saying. This is an as-applied challenge.
Exactly. Yes, sir, it is. Okay. Thank you. The trial court denied plaintiff's unconstitutional challenge to the application of Tennessee Code annotated. That's why I interchanged application for enforcement, but I'd rather use the word application to make it a lot simpler to see my argument. The trial court denied this constitutional challenge by stating the constitutionality of Section 122 has previously been decided by the Tennessee Court of Appeals in the case of Jackson versus HCA Health Services of Tennessee. Plaintiff appellate is challenging the unconstitutional, unfair, and unequal application of Tennessee Code annotated 2926-122A, which is filing the certificate of good faith between self-represented persons and licensed attorneys, and not the constitutionally, Your Honor, of the statute, as you alluded to a little while ago. Thus, the trial court erred on this constitutional issue. The Equal Protection Clause of the 14th Amendment to the United States Constitution in pertinent part states, no state shall deny to any person within its jurisdiction the equal protections of the laws. The appellate record shows that plaintiff consulted with 5 ophthalmologists and 8 additional expert witness contacts for the purpose of complying with the good faith certificate of Tennessee Code Annex 2926.22a, by serving the good faith. These efforts by the plaintiff appellate were truly extraordinary. However, these efforts were truly unsuccessful and thus constitute an unconstitutional application of the law between pro se litigants and licensed attorneys. Additionally, licensed attorneys can comply with the good faith certificate much more easily than pro se litigants because of their superior legal training, knowledge, education, experience, and vast connections within the medical and legal communities. These undisputed facts further constitute...
Well, Ms. Ruff, I don't know. Some in the medical community don't think much of lawyers.
Well, I can understand what you're saying, but I think you understand the breadth of my argument there. Thank you, Your Honor. These undisputed facts further constitute an unfair and unconstitutional application of Section 122 between pro se litigants and licensed attorneys. Additionally, the good faith certificate is further unconstitutionally applied between pro se litigants and licensed attorneys because it gives licensed attorneys far greater access to Tennessee courts than pro se litigants who cannot find an expert witness. As a matter of fact, finding an expert witness for a pro se litigant in a Tennessee Healthcare Liability Act case is a rare occasion, as in my experience will show that. And I believe I speak on behalf of many pro se litigants too on that matter. And for a licensed attorney who can produce such expert witness easily. As a result, pro se litigants find their cases dismissed with prejudice much more often than licensed attorneys, which further confirms that Section 122 is unconstitutionally applied to pro se litigants. Consequently, the fair remedy for this honorable court in this matter is for the appellate court to find and or declare that Section 122 is unconstitutionally applied between pro se litigants and licensed attorneys, and or level the playing field by excusing pro se litigants from complying with Section 122.
All right.
Thank you, Your Honors, for hearing.
Thank you. Thank you, Mr. Ruff.
Yes,
All right.
sir. Thank you.
We'll now hear from the appellee. Good afternoon.
Steve Anderson of the Nashville Bar. On behalf of Vanderbilt Medical Center, I'm only going to address briefly really the 2 noted exceptions under Section 122A to the failure to file a certificate of good faith. It is undisputed that there was no certificate of good faith filed in this case along with the complaint. Section 122A is obviously crystal clear about what happens unless there's these one of these 2 exceptions applies. And I'll hit those in just a second. The one thing that Mr. Ruff just said, though, that I do want to talk about, it sounds like to me he's trying to ask this court to treat Dr. Fowler's statement that's attached to the complaint as essentially a de facto certificate of good faith.
Right.
Well, there's a couple of problems with that. Number one, that Mr. Ruff never raised this at the trial court below. I've scoured the record, and I don't see where he ever made this similar argument of, well, okay, that's my exception. That is my certificate of good faith. But furthermore, even if this court wants to go past that procedural problem hurdle, if you look at Dr. Fowler's statement, which is attached, I think it's Exhibit B, if I recall, to the complaint. I may have that letter wrong, but it is definitely attached to the complaint. It reads, frankly, as just a doctor's report of Mr. Ruff's eye condition. There's no statement in Dr. Fowler's statement, or really, as best it's put, it's almost like a clinic note in part. There's no statement that there's a basis for a lawsuit here, or even the potential for the basis for a lawsuit here. So I think the court can dispense with that because of those 2 reasons. If we go now to the analysis of the 2 exceptions, obviously the first exception is extraordinary cause. It doesn't apply here. Now, I will say Mr. Ruff appears to have gone to great lengths to have tried to find an expert witness based on what he has represented to the trial court and to this court. But that's obviously not extraordinary cause. A lawyer would have stopped. I think most litigants would have stopped and realized there's no basis for a lawsuit because I don't have an expert who's willing to sign on to it. So that Obviously, if that were extraordinary cause, it would subsume the rule. So what I really want to focus on is this medical record issue. What the trial court found is two key things. The trial court found two things. He said that Mr. Ruff admitted during the hearing, this is in the order of granting the motion to dismiss, that Mr. Ruff had admitted during the hearing that he had never complained either to VUMC or to outside counsel, me, once I got involved in the case, about the absence of medical records. Trial court also found, quote, that plaintiff has submitted no documents to the court demonstrating any effort to obtain additional medical records after sending a medical authorization in July of 2021. And Your Honor, that's important because Mr. Ruff didn't file his lawsuit until July the 26th of 2022. So he had 6 months from the time of the authorization being sent to the time of the complaint being filed. There is not a piece of correspondence, an email, any kind of phone call, nothing. And then even after he filed the lawsuit, there was no complaint, hey, I don't have access to my medical records. And to my knowledge, I cannot see where Mr. Ruff has ever challenged either of these findings of the trial court about the medical records issue. And as Your Honors know, that statute says the exception is upon a showing that the absence of medical that the failure to obtain a certificate of good faith was due to the absence of medical records. And there's just simply no showing here. And the last thing I want to say on this medical records issue, if the court even gets to this point, if you look at the authorization that Mr. Ruff sent, which is part of Exhibit C to his complaint, he has in there a request for things such as emails, inter-office memoranda, notes, documents relating to phone calls. And this is a quote, complete responses under oath regarding the plaintiff's email to Vanderbilt Medical Center's deputy CEO. Mr. Ruff sent an email to the deputy CEO of the medical center. So there are things in his authorization that don't even constitute medical records. So ultimately, this court's left, and the trial court was left with nothing showing what records were allegedly missing, how did this impair him, and so forth. And so the trial court properly granted the motion to dismiss and properly denied the Rule 59 motion.
Mr. Anderson, I want to make sure I'm looking at the same thing you're looking at. When
Yes,
you
sir.
talk about Dr. Fowler's, and we're looking at Exhibit D, is that correct?
I don't recall, Your Honor. I said B, but it may be D.
Okay.
That is it. I believe that is it. And it reads like a physician's clinic note, in my opinion. I mean, that's how it reads. But there's certainly no statement about a basis for a lawsuit in it. Thank you.
All right. Thank you, Mr. Anderson, and thank you, Mr. Ruff, for your arguments. Mr. Ruff, we will take this matter under advisement, and at the appropriate time, a written opinion will be released, and the clerk will provide that opinion to you at the address that you provided in your papers. Thank you. Thank you. That concludes the afternoon docket.